for welcome address.
Thank you, Jyoti Kumar, Professor. Good morning to everyone. Welcome to the webinar by Institution Innovation Council of Shadan College of Engineering and Technology on the title Why IP is Important in Academia by Dr. Muhammad Ikramullah Aman, Head of the Department of MBA and is a Placement Training Officer as well. And on behalf of organizing committee, Jyoti Kumar, President IIC, Dr. Ilyas, Vice President IIC, Dr. Nasif Khan, Convener IIC. So I would like to thank for organizing this webinar. Thank you very much.
Kumar sir?
Yes, sir. You can start your presentation, sir.
I feel privileged to be here and given a chance to give a presentation or webinar on this given topic. I'm thankful to our management, Dr. Jyoti Kumar sir and your team. It is my privilege, sir.
Welcome, sir. Welcome.
Myself, Dr. Muhammad Ikramullah Aman. I'm working in the Shadan College since 23 years, sir. I'm head of the Department of MBA. I'm looking after training and placement activities also. So I will be sharing my screen now, and I will start, sir. Jyoti Kumar sir, please remove the. It is showing the host disabled participant screen sharing. Please enable screen sharing, sir. Hello. 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 Jyoti Kumar sir.
Yes, sir. Yes, sir. Yes, sir.
Please enable the screen sharing, sir. It is showing that it is disabled.
Just a minute. Yes, sir. You can share now.
Now it's a webinar on why intellectual property is important in academia.
Your screen is visible. Please press
Organized by
F5, sir. Press F5, sir. F5.
Okay. Okay, sir. Thank you, sir. Hello, am I audible?
Yes, sir. Your voice is clear and
Hello.
screen is also visible.
Okay, sir. Okay, sir. Uh, very good morning to one and all, sir. My topic is why intellectual property is important in academia. Academics deals with we can say almost
Sir, little loud.
every bit of academics deals with our mental activities, our intellect. Sir. All of us are engaged in different types of intellectual activities. The brain of a typical professor or a scientist is, you can say, wired in such a peculiar way. It is always focused on performing meticulous analysis of problems and issues that may appear very complicated to a layman. So from that, you can say the source, the brain, continuously or subconsciously,
Sir, cross tag.
an inventor, an author, or a faculty member can subconsciously, a thought process will be going on inside his brain. So during that thought process, different ideas will be emerging, evolving. So those ideas, majority are irrelevant ideas, but for a person who is involved in academics or a person who is involved in research work, so for him, that subconscious activity will be always focusing on some problems, some issues. The problems could be related to business or non-business, social problems. But he will be, being an academician, being a researcher, he will be involved as he is already preoccupied with different activities of research. So his mind will be also preoccupied with different ideas. So when we say that intellectual property, it means that it is the original concepts and ideas conceived in the mind. Different ways authors have defined it. And we can also say creations of the mind, or basic construction of human intelligence, inventions of the mind. So these concepts or ideas or creations or basic constructions, or you can say inventions, they are expressed in the form of ideas. Ideas are intangible. We cannot see them, we cannot touch them, but they originate from our intellect, from our mind, from our brain. And many ideas, if they are put at the right place, if they get the right environment and the available resources, those ideas can say germinate into just like seeds into big trees. They can give fruits to the whole society, the inventor, even the nation also. So we are here dealing with the intellectual property. So these ideas, which originate from the mind of an inventor, belongs to that inventor. So that is a property of the inventor. The intellectual property is nothing but ideas originating or being conceived in the mind. So our mind is creating, and that is, you can say, a subconscious project. So these ideas, when we say that the new and fresh and novel and unique ideas are generating from the mind, we call it as creativity. This creativity or generation of ideas, they can be transformed into some applications, some physical form, some devices. When they are transformed into some device, maybe the device might be in a crude form, but that device in its crude form will be called as an invention. But this invention requires refining, further refining. And if it is refined properly and commercially it is made viable, then it is called as innovation. So creativity leads to invention, invention leads to innovation. So our ideas which are emerging in the mind are our intellectual property. That is our property. That is the property of the inventor. Goods or services are basically
Recording in progress.
in the beginning with ideas. Intellectual property. We can have a small discussion on about the nature of intellectual property. It is intangible. It is having value. Because it has value, it must be protected. The owner has a right over its production and sale, licensing also. But these rights are given for a limited period of time in exchange for disclosing the invention to the public. The owner of the inventor is expected to disclose the invention to the public, but he will be given some security for a given period of time. He can extract benefit from that idea by commercializing it. A second aspect in the nature of intellectual property is coexistence of different rights of inventions. Example, simple example, an invention can be patented and the photograph of the invention can be copyrighted. The same invention is being patented, its photo is being copyrighted. Similarly, a design can be protected under Design Act, and the design can also be incorporated into a trademark. So we can have a design of a automobile, of a instrument, of any device, of a building. Those designs, if it is novel, fresh, unique, and new, and can be applied or practically put into execution, and if we get it registered in the Design Act, the same trademark also. That is the second thing. Third thing is exhaustion of rights. The rights given to a patent or to a copyright or to a trademark all have a limited period of time. Any new method, new product, new process, all comes with the patents. Every invention considered with products, new methods, they come under patents. So Government of India, even in USA also, they are giving 20 years of time for the inventor to extract the benefits from his invention. 20 years, he can convert the idea into a physical form, a viable product, and commercialize it and sell it, produce it and sell it. For 20 years, he can or she can earn money, earn profit using that invention. But in case of design patents, 14 years time, or after 20 years in case of patent. What are
Recording in
biopatents?
progress.
In pharmaceutical company, in industry, researchers are searching for, are analyzing animal products, even human beings also. And they are trying to extract insulin and such other hormones So they are filing patents for whatever they have extracted. So all those come under biopatents. Genetically engineered organisms or plants, you will be surprised to know that the science anti-cancer purple tomatoes, golden rice, but not white, it is of golden color, golden rice. Featherless chicken, different genetically engineered animals, plants have been created by human beings.
Sir, YouTube check பண்ணுங்க சார் வரதான் பாருங்க.
So there is a continuous development in IP, intellectual properties. Even software companies, they are bringing out latest software softwares and applying for copyrights.
சரி சார் யூடியூப்ல
Artificial intelligence, blockchain technologies, digital products, and many more are examples of softwares whose copyrights have been applied for. So all this intellectual property, which belongs to the inventor, we are, as a lecturer, as a professor, we too can become inventors, authors. It requires a lot of thinking, critical thinking, lateral thinking, and a lot of creativity. If at all we get good ideas, so we definitely aspire for that our idea should be protected. It should not be copied by others. First thing is, I must disclose my idea, and I should get the benefit of the idea. And even the public and the whole society and the nation should get the benefit of the idea. That disclosure of the idea in the form of a patent or a copyright or a trademark, anything, that disclosure must be encouraged. So our invention should not remain secret. They must be encouraged. In that process, in that way, we will be improving our creative inventions and innovations.
கமல் சார்
So basically, the importance of intellectual property in academia is to let the authors disclose their inventions. Let the inventor come out with the ideas. Let not those ideas be kept as a secret and benefit only the inventor. Let it come out and let it benefit the whole humanity. So that encouragement must be made to the authors, to the academicians, researchers. Every possible efforts must be made by the management, by the colleges, by the universities to enable the creativity of the faculty members, of students to prosper, to increase and lead to inventions and innovations. Secondly, the progress and the good of humanity remain in the ability to create and invent new works in the field of technology and culture. Whatever new is coming from technology and culture, humanity is using it. A tremendous or a lot of convenience we are enjoying using latest technologies. Next point is promotion and protection of intellectual property, promote economic development of the nation, generates new jobs and industries, improves the quality of work. So this promotion of intellectual property is rather helps in development of the whole nation, developing new industries, overcoming unemployment, and ultimately improving the quality of life of all the citizens of India. Then we can also say this also, that intellectual property helps in balancing between the innovator's interest and the public interest, provide an environment where innovation, creativity, invention can flourish and benefit all. So So there is balance is struck between the innovator and the public. Both will be benefiting from this disclosure, and you can say these are intellectual properties, ideas. All ideas are intellectual property. Those many ideas are very valuable, very precious. So there must be some system to protect the rights of the inventor. That inventor must be able to get whatever he has spent and efforts he has made to bring out one idea. For example, in pharmaceutical companies, I too have done B pharmacy. So while our professors used to tell us that it takes almost $500 million to bring out one unique medicine, a new drug, and almost it takes 5 to 10 years of research, after which a drug or a chemical or a medicine, a medicament is we can use for human beings. So a lot of efforts are required, a lot of money is also required. So that idea must be protected, given some legal rights. That is where comes intellectual property rights. The intellectual property right is a kind of legal right that protects persons' artistic work, literary work, inventions, discoveries, symbol, design for a specific period of time. Governments have put a limitation also. A person, an inventor, has come out with a good idea, and is now he is able to commercialize it also, earning profits also. There is a limit for earning of profits. The government have given a limitation of time within 10 years, 20 years, some time is there. Just above we have seen, for patents, 20 years time is given by the Indian government. Even US government also gives 20 years time. But till 20 years, inventor can enjoy and earn profit. After 20 years, that right for that invention will cease, will stop. Others can copy that idea and produce the same or better product or service at a lower cost. So some specific period of time is also given. Intellectual property owners are given certain rights by which they can enjoy their property without any disturbances and prevent others from using them. Where inventor enjoys monopoly rights in production and sale. That monopoly he will be enjoying till that period, patent period. After that, it will be made public. Anybody can copy it, anybody can produce it, anybody can sell it. That competition will increase. With the increase of competition, supply will increase, or competition will increase. Automatically, prices will come down. Now, there are some kinds of intellectual properties. The first type is patent. 4 types are there, popular types. Patents, copyrights, trademarks, and trade secrets. So let us first discuss on patents. What are patents? Now, any new production, any new invention, any person have come out with a new product, new method, new process, something new. So we will call it as a patent. We will call it as an intellectual property or invention or innovation, given some security. That security is given through with the help of some rights. The government gives a special right. So a patent, that right is called as patent. So a patent is a special right granted to the owner of an invention to manufacture, use, and market the invention, provided that the invention meets certain conditions laid down in law. This right is exclusive right, which means that no other person can manufacture or produce or use or market that invention without the consent of the patent holder. Others cannot copy it. If somebody else copies or tries to manufacture it, produce it, and sell it, so the inventor can sue that person in court of law. So the patents is a exclusive right. It is an exclusive right given to the inventor, but it is for a limited time only. There are three types of patents. Utility patent covers inventions giving material benefits. Any new device, new material, new process, new technological procedure, genetically engineered organisms like anti-cancer purple tomatoes, golden rice, etc., all whatever comes in a unique manner, new, a fresh manner. Nobody have seen earlier. Nobody have discovered it earlier. Nobody knows it. Something new. That too relates to some benefits, utility. The utility patent covers inventions giving material benefits to the inventor, to the public who are using it. Second type is design patents. Now, design patent is a different patent. It relates to appearance, aesthetic appearance. It does not relate to function. So design patent covers unique appearance of the object, new appearance of the object, purely aesthetic, not functional. Architectural elevation of a building. I can say I am proud to be a part of Shadan Group. Our Shadan building is in the shape of octagon. I'm sure no such building exists in Earth having the same shape. So even Shadan Group can go for a patent for this design, in this design patent. Other such many buildings are there in Hyderabad, but the shape of a fish-shaped building. Some buildings are of lotus-shaped buildings. So the appearance of the object can be used as a design patent. And the contour of the shoe can also be applied for a design patent. Different computer icons. iPhone patented. Example: iPhone company, it has patented slide to unlock feature. It is way back in 2010 when the mobile phones were being introduced. It was the beginning era. So the slide to iPhone company in its phones, and it was patented with this number on August 17, 2010. So design patents cover appearance of the object. Third is plant patents. Above we have discussed it earlier also. Plants are asexually reproduced. New plants are being reproduced. Plant breeding is being done. So if a cultivator is able to breed a new variety of plant, a new color, something new. For example, just now above we have said of golden rice coming in golden color. One example I have given here: Idaho potato was developed and patented by Luther B. in USA, and he had developed 800 more varieties. So he applied for patent in US for Idaho potato. So that is called as plant patent. So all the patents are of three types: utility patent, design patent, plant patent. Patents are nothing but special rights given to the owner, to the inventor, so that he can manufacture and store and stock and give to somebody, but for a limited time period. We must also have an idea about the history of patent also. In 1790, the first US patent legislation was 1790. Almost 230 years back. And the first US patent was granted to Samuel Hopkins on 31st July 1790 for the fertilizer potash and pearl ash. So that person, Samuel Hopkins, has developed a new method, a new process to uh, create, to develop this fertilizer. Till date, US Patent Office has issued 8 million patents. It's available on internet. Even for all. So Novartis was expecting the Gleevec drug can be slightly modified, and again next 20 years we can enjoy monopoly. So the Patent Office of India rejected his application, saying that there is no enhanced efficiency. Then the company approached Supreme Court, and it was a landmark case. A judgment was given, and Supreme Court said the enhanced efficiency means therapeutic efficiency, and which was not found in Gleevec drug of Novartis. Only minor improvements were made, and therapeutic improvements were not made. The Supreme Court rejected the application of Novartis, Gleevec medicine. Novartis belongs to USA. USA almost it frowned and was very angry. Now the USA is against the Section 3D IPR of Indian government, and USA has put India in priority watch list, and possibly will try to put some international sanctions. But India has stood strong with its this idea of removing evergreening of patent. So evergreening of patent was removed by Indian government. Other countries also followed. Brazil also adopted this method, this law, and many countries are there which have adopted this law. So with this 3D, Section 3D IPR, the drugs became affordable. The prices were lowered. After 20 years of patent period, all the drugs in 1970, Patent Act was made. By 1990, 20 years at Patent Cooperation Treaty, he has to abide to it, become a member of it. So territory is a limitation for patent. Next comes patent lifespan. Patents, 20 years lifespan is there in India and USA for patents. 60 years lifespan is there for copyrights in India, and that too 60 years after the death of the author. And for trademarks, again, 10 years lifespan is there. For trade secrets, there is no lifespan. Indefinitely, as long as that secret is hidden, you can use it. There is no limitation of time there. One small difference is there for copyrights. In USA, instead of 60 years, 70 years is a lifespan after the death of the author. In India, we have 60 years. So this is what is patent is. The second type of intellectual property is copyright. We all are aware of the copyrights. Whenever we open a textbook, we will find in the initial pages a copyright C will be there, a symbol C will be there. In every textbook, we will find a symbol C. It means that the author has applied for a copyright for that textbook. Nobody can copy it. Even if we copy a sentence 4 to 5 words, if it comes into the notice of the author, he can easily sue us. He can go to court for justice. That is the problem. That is why in all our projects, students' projects, thesis of PhD or MPhil, in our college we are following anti-plagiarism softwares to overcome this copyright difficulty. So this type of protection is given to creative work such as writing, drawing. It protects the creative and artistic expression of an idea. So books, softwares, architectural drawings, articles, blog posts, graphic designs, movies, even music also are all covered by copyright. So governments are very particular about securing the rights of such an inventor who is a creative person or who is writing and drawing, designing something very unique. Third type of intellectual property is trademark. This protection is given to original words or combination of words, symbols, designs that you create to represent your business. The symbol TM at the end of a word indicates that the trademark protection is claimed. Government is there securing that trademark. And R in a circle means that the trademark has been registered. I want to share a few examples of trademarks. All of you are aware of it. All these are different trademarks. So many are there. For example, geographical indicators, Darjeeling tea. This is also one intellectual property. In the last, we will discuss it about. We have Colgate and Dell and FedEx and Castrol. So many different trademarks are there. So these are trademarks are created by, designed by the companies. Nobody can copy it. They have their own value. So they have applied for the trademark rights. So nobody can copy it. All these are pharmaceutical medicines who have been granted patents. Many are there. A huge list is there. I have taken a snapshot of one page only. Number of thousands of patents are given to different pharmaceutical medicines, drugs. Other unique products are there. Pen with a scanner. With a machine as small as a pen, you can transfer text from paper directly into a computer. Christopher Paharius invented the C pen, the pen with a scanner. The pen is having a small scanner at the tip of it. The possibility to move. Yelva Dahlen, a physiotherapist who often encounters children with severe functional disabilities. To give these children the possibility to move happily, she invented Hopolec, an instrument. Handicapped children can use it. Steel kidneys, blood rocker. So many are there. Long list is there. You can just browse through Google and you will enjoy different hundreds of patents.
எல்லாம் மனுஷன் எல்லாத்தையும் ஈக்குவலாக கொடுத்துருந்தாங்க. நான் என்ன சொல்றேன், ஒரு பர்சன்ட் பிரிச்சுன்னு எடுத்துக்கோ, வச்ச 2 வருஷம் யார் பிரிச்சு சொன்னது? ஆமா ஆமா, உனக்கு வேற ஒன்று மட்டும் ஒரு பாக்கெட் மட்டும் பிரிச்சு கேட்டான கோட்டீஸ்வரன் லோடா சொன்னீங்க.
Now come to we are aware of what copyrights are, patents are. Now in our field, in our academics, we are involved very much in generating new ideas, new concepts. We are using different methods of teaching to generate new ideas. Students are also coming forward, bringing new ideas in their projects, mini projects, major projects. So whenever we are getting any new idea, a student is getting a new idea. So how to apply for a patent, how to apply for a, I can say, design patent. So there are, a procedure is there as per the Indian Government Patent Act. Almost the same procedure is followed throughout the world. In US and European countries, all procedures are given. I have one of my friend who is a intellectual property professional or agent. From his help, I was able to get the links through which we can apply for a patent. Different colleges and universities are applying hundreds of patents coming from their students and staff. Even Shadan Group also can apply for patents. It is having a simple procedure. When an idea is generated, that idea is only a thought, an intangible thought. It has to be put into practice. If we are able to, or if we succeed to put that idea into some practice, let it be a crude form, an invention takes place. That invention, if it is refined, researched again and again, it is made worthy of commercialization, then we can file a patent. Patent drafting, patent application is a very difficult part. It is not so easy. It is having so many things, techno-legal. It is a techno-legal document. A professional can fill that application or draft is better than us. So we have to fill up an application. It requires many details of the invention, each and every minute detail of the invention. After filing the patent office, India, in every state, we have got patent office. So in patent office, that application will be sent, and the patent office will examine the application. Lately, some our faculties too have applied for patent in Australian patent office. It's a very good thing. I should congratulate them. But in this whole process of application, where do they stand? Whether they have applied for, whether examination have been done, whether that patent have been allowed, issued, it must be also seen, and we should try our best to enable examination and allowance and issue of patent. The same steps can be what is the procedure and steps for getting patent? What is the cost of getting patent in India? Time required for getting patent. The first step, invention disclosure. We require to give the details about the nature of invention, the description of the invention, the application or usage, similar existing products, similar to our product, our invention, advantages of our invention over existing products, and complete diagrams, sketches, illustrations. Every detail about the invention has to be given in the patent application. If we are doing by ourselves, there is a high possibility that we might fail. So it is better to take the help of a intellectual property professional, IP profession. So he will take some fees, but he will because he's having experience, he will draft the application in a very good manner. The cost depends on several factors. Government is having a fees for the form, the professional charges of the IP professional, and number of claims we are making. Sometimes what happens that in one invention there are many applications possible, but are not visible to us. We might see only few applications of the invention, few uses of the invention. So we might be unable to uncover more usages. So when we are claiming for an invention, so we might claim for 2 or 3 usage or applications of the invention, but there might be more applications hidden. After some time they will surface. So we must be careful at what we are claiming. So we should try to claim everything, whichever is new, which fulfills the patentable requirements. So we must claim everything. Approximate cost comes around 55,000 to 1.5 lakhs. Second step, this cost is for the whole process. Now stepwise what cost comes, I will tell you. Non-disclosure agreement, second step. Non-disclosure agreement. When we are applying for patent, our invention, the details should not be disclosed to any other party, third party, any other agent. To whomsoever I am disclosing my invention, he should keep it secret. If it leaks, if my description and my idea invention and the laws, patent laws of the country. He will be having the skills to draft the whole application. So he will proceed using 2 ways. The first is provisional patent application. Second is complete patent application. Provisional patent application, it relates to the early stage of research. Now we have idea has been converted into some crude form. It has not been refined. So before refining, before commercializing, before industrial application, in the early stage, so we are developing it, designing it further. So in that stage, this provisional patent application will be there. But the important thing is, if we apply for provisional patent application, the date of application is very important. So we will be able to secure the filing date of application. From that date, we have got 12 months time, 1 year time to submit our complete patent application. So within 12 months, we are supposed to submit the complete patent application. So to fill up this provisional patent application, 7 days time is required and cost comes around 15,000 to 25,000. After this, let us suppose our initial research has been refined, now we are ready, so we can go for complete patent application. The filing requires complete description of the invention with diagrams and claims. Complete, every minutest details of the invention should be included, should be filled up and submitted in this complete patent application. Time required again here is 15 days. Cost comes from 25,000 to 40,000. Government fees is 1,600. Step number 5, the publication of the application. Now that the patent office, the government office, the patent office will publish our application. That publishing will be done after 18 months from the filing date. Some form 9 is there. It should be filled up and submitted. So after 18 months, 1.5 years, the application will be published by the patent office. For that, the government fees is to 2,500. Sixth step, request for examination of the patent. Once our application is published, that is, it is approved, now we will request for examination of the invention. Please examine our invention. The patent office will examine. The controller will give the patent application to the examiner, who will examine the application using patentability criteria, the 3 criteria. Novelty and industrial application, and third one is non-obviousness. So those 3 criteria has to be followed everywhere. So using those 3 criteria, the application will be examined by the examiner. If at all the examiner finds that the invention is similar to some other patent already filed, so he will raise objections. So objection of similarity of invention may be raised if found in the first report. If at all there is an objection, then the inventor will have to overcome the objection by resolving it, by giving an explanation, by giving a reason that there is no similarity and whatever possible reason is there, and he has to establish the fact that his invention is purely novel, new, unique. So once the objections are resolved, then 8th step, patent is granted by the Government of India. That grant of patent is notified in the patent journal also. Now the patent application link of India. I can share this link also to all of you. This is a link I have got from one agent, and I've opened the link. This is the home page of Indian Patent Office. This screenshot I'm showing here. Let's hope we try to generate new ideas. We try to stimulate and motivate students to generate new ideas, and we are able to convert these new ideas into some mechanical devices, software programs, marketing strategies, procedures, methods, and we are able to patent our inventions. I hope session is helpful to all of you. I'm very thankful for the participation and encouragement all of you have given to me. And of course, I'm thankful to the management, our respective principals, sir, directors, and the president of IIC and all the team members of IIC, that they have given me an opportunity to give a presentation, a webinar on this topic. Let's hope we achieve some patents in our college. Okay, Jyoti Kumar sir.
Thank you, sir. Thanks for your excellent
Hello.
information. Really, we have learned a lot about how to file patent and how to take this to the next stage till getting grant. You have not only discussed about the Indian patents, you have discussed about filing patent in other countries also. So the session is very useful, sir. I request you to share the PPT so that we will post in our WhatsApp group, so that faculties will be get benefited, I think. Thank you, sir. Now I would like to invite Mr. Kamal Kumar for vote of thanks. Sir, mic on.
Yeah, thank you, Jyoti Kumar sir. Yeah, vote of thanks by me, myself Kamal Kumar, Associate Professor, Shadan College of Engineering, Computer Science Department. I thank Dr. Muhammad Ikramullah Aman HOD of MBA, and as well as he is training and placement officer of Shadan College of Engineering, for his valuable speech on why intellectual property is important in academia. It's very useful and informative for all of us. I thank participants, and I thank our organizing committee, Dr. Jyoti Kumar, President of IIC, and Dr. Ilyas Sir, Vice President IIC, and Dr. Nasif Khan, Convener IIC. Above all, I thank Dr. Atikur Rahman, Principal, Shadan College of Engineering, and our directors for giving opportunities to have webinars like efficient speakers. I thank once again to all of participants. Thank you very much.
Thank you, sir. Thank you so much, sir.
Okay, sir. Thank you very much, sir.
Shall we close the session, sir?
I conclude here, sir.
Thank you, sir. Good, good. First, you didn't turn on the mic. Also, you didn't turn on mic first.